Hello, I'm Dominic Walker, JMW's Inside Man, and I'm with Ameliah McLaren-Parker. Ameliah is a solicitor in our contentious trust and probate team. Hello, Ameliah.
Hi, Dominic. How are you?
Very well, thank you. So, Ameliah, we wanted to talk about, well, really the sad story of Barbara Jadrych, who was in a relationship with a man called Mr. Crouch. Mr. Crouch is involved in the football business and was for a long time. And the couple had a daughter, but unfortunately, just before they were going to get married, Mr. Crouch passed away, which obviously left Miss Jadrych and the daughter in a very unenviable position. So I just wondered if you could just sort of give us an outline of what's happened and what Miss Jadrich's options were in ultimately making a claim against Mr. Crouch's estate.
Yeah, so it is a really unfortunate situation by which she's been left out of his will, and obviously she does have a child with him. So it appears that in this case, Miss Jadrych would have brought a claim under the Inheritance Provision for Family Independence Act on the basis that she was being maintained by Mr. Crouch immediately before he died. So there are certain categories of people that the Act seeks to protect. So whether that be a child of the deceased, a spouse or civil partner, a former spouse or civil partner of the deceased, and in this case, somebody who's been maintained by the deceased prior to their death. Miss Jadrych would have fallen into one of those categories by being financially dependent on Mr. Crouch. So in this case, she would have claimed reasonable financial provision for maintenance. And the standard of provision does vary, and it depends on the status of the applicant. So, as you mentioned, they weren't married, and unfortunately died 3 weeks before they were due to get married. So the standard of provision is that which would have been reasonable in all circumstances for her maintenance. Whereas if they were married, then the standard of provision is slightly higher. So it's what would have been reasonable for a husband or wife to receive, whether or not it's for their maintenance. So usually the standard is more generous to a husband or wife of the deceased.
And Ameliah, although this is quite a high-profile case, it won't be an isolated thing. This must happen quite often. If somebody came to you with a similar set of circumstances, what sort of things would you be looking at?
Yeah, so we'd conduct an initial fact-finding exercise, and we'd look at the relationship that the claimant had with the deceased, how they dealt with their finances. We'd also look at their own financial resources, so that we could conduct an assessment as to what their own financial need is. We'd also look at the interests of any other applicant and the beneficiaries under the will, so that we could identify what competing interests there are, and if so, to what extent. It's also important to look at the nature and the size of the estate in order so that we can quantify any potential entitlement.
And what's your practical advice to somebody with a similar scenario as what's happened in this case?
So I would advise people to act fairly quickly, as there is a 6-month time limit from when the grant of probate is issued in an estate in order to bring the claim under the Inheritance Act. So I'd say that if you are concerned that you've been excluded from a will and you feel that you should have been provided for, I would seek legal advice at the earliest opportunity.
Thank you, Ameliah, and I think the key there is get on the phone to you and speak to you as soon as possible. You can contact Ameliah directly, insideman@jmw.co.uk, or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.